You have no say in anything in this house. The deed was transferred 2 years ago. You're just a guest here." Brandon said that with both hands in his pockets, looking toward the excavator that was leveling the last of the ground, where my rose garden had grown for 23 years. He didn't look at my face. His voice was calm in the way of someone who had rehearsed this line and knew he was standing on the side with the power. I stood at the entrance to the backyard of 1847 Wisteria Lane in Pasadena, the craftsman house built in 1927 that Harold and I had bought in 1988, the house where my daughter Diana grew up, the house I had transferred to Diana and Brandon 2 years earlier because they said it would protect my estate from inheritance taxes. I looked at the patch of flat red-brown dirt where my garden had been. Nothing left, and not one of the 27 heritage rose plants, not the cedar trellises Harold had built by hand with a craftsman's skill, not the Graham Thomas climbing rose, the warm butter yellow variety whose blooms the Pasadena Rose Show judges described in 2015 as one of the finest examples of heritage climbing roses in greater Los Angeles when they gave it first place. Nothing but disturbed earth and the smell of diesel in the late afternoon California March air. Workers from prestige pools and spas were driving stakes to mark a swimming pool layout, the L-shaped pool with a spa that Brandon had shown off at dinner the week before, the catalog left right on the kitchen counter, as though it were good news to be shared. I stood there, couldn't speak for about 30 seconds, not because I had nothing to say, but because too many things were moving through me at once, and none of them were calm enough to say usefully. Then I turned and went inside, walked through the kitchen, sat down in my chair at the corner of the kitchen table, the only seat in this house where I still felt I had a presence. My name is Margaret Adele Whitmore. I am 68 years old. I am a retired music teacher, an amateur gardener who has won 3 awards at local rose shows and 1 national recognition. And on that Friday afternoon, the 15th of March, I sat at the kitchen table of my own home and looked at my hands. So this is how they repay me? I need to tell you about 2 years before that, about the decision I made, and about the way people sometimes believe the wrong thing because they love the person saying it. In August of 2022, Brandon sat down with me at the kitchen table after dinner and started talking about estate planning. That was the kind of thing he did, use professional financial language to make everything sound like a smart business decision rather than what he actually wanted. The house in Pasadena is probably worth around $1.8 million right now, he said, his tone the measured calm of someone who has prepared a presentation. When you pass away, it will go through your estate, and Diana will have to pay federal and state inheritance taxes. That could mean $200,000 to $300,000 going straight out the door. The solution is to transfer it now, he continued. A legal gift while you're still living. It avoids inheritance taxes and protects what you've built for Diana. Diana sat beside him, nodding. Mama, I looked into this carefully. This is the smart way to protect what you've created. The house is still your house. You'd still live there exactly as you do now. Only the paperwork changes, I asked. What rights would I have after the transfer? The right to live there for life, Brandon said. We'll make sure that's in the contract. Life estate. Lifetime right of use. Even though the deed would be in Diana's name, you'd have the legal right to live in the house as long as you want. And the rose garden? I asked. Brandon looked at me the way people look at a question they don't think deserves a long answer. The rose garden is still the rose garden. You still take care of it. Nobody touches the rose garden. I asked one question that I should have pushed much harder. What specifically does the life estate agreement say? Brandon showed me a 2-page summary, not the full contract, just a summary prepared by his law office. I read it. Dense legal language. I understood the general meaning, but not every sentence. What I didn't know at the time was that the summary had omitted several important provisions in the actual agreement. I signed without having my own attorney present, the single biggest mistake I made in 68 years of living. In September of 2022, I signed the transfer. Before this story moves forward, I need to go back to Harold and to the garden, because no one can understand that Friday afternoon without knowing what lay beneath the dirt that the excavator had flattened. Harold James Whitmore was born in Pasadena in 1949, the son of a carpenter and an elementary school teacher. He grew up knowing the name of every old street in this city, the history of every craftsman and Tudor Revival and Mission Revival house built here in the early decades of the 20th century. He was a carpenter for 34 years and knew wood the way craftsmen who love their trade know it, by smell, by grain, by how it responds to weather across the seasons. I met Harold in 1979 at a small concert at Pasadena Civic Auditorium. He came alone, sat in the back row, and during the intermission told me that I played piano the way someone plays when they actually have something to say, rather than just performing. I was a piano teacher then, not a performing artist, and that was the best compliment about my music I had ever received. We married in 1982. Diana was born in 1983. We moved into the house on Wisteria Lane in 1988 when Diana was 5. 3 bedrooms, a front yard with 2 old oaks, and a wide-open empty backyard. In 1991, Harold suggested planting roses, not because he knew much about roses. That knowledge was mine, learned from books and from the Rose Society. He suggested it because he said, "Adele, we need something living in this backyard, something beautiful and patient that comes back every year." We started with 5 plants from a small nursery on Fair Oaks Avenue, and I learned technique from the Rose Society of Pasadena, a group of rose enthusiasts who met monthly to share experience on pruning, fertilizing, pest control. Harold built the cedar trellises, calculating angles and weight-bearing capacity, fitting each joint with the precision of a craftsman who understood that good work is invisible when it's right. 23 years later, the garden held 27 rose plants of many varieties, heritage, climbing shrub, modern hybrids, arranged so that different plants bloomed at different times, giving the backyard continuous color from March through November. I had entered 3 Pasadena shows and won awards, been mentioned in the Rose Society newsletter, and in 2017 had a journalist from the Pasadena Star-News come to photograph the garden for an article on Pasadena's most beautiful private gardens. Harold died in August of 2016, a stroke in the backyard on a Saturday morning while he was pruning roses. I was in the kitchen making coffee. When I came out with a glass of water, He had sat down on the ground next to the Graham Thomas and could not lift his hand. After that, the garden was where I went every morning, not to mourn in the theatrical sense, but because when I was in that garden, hands in the soil, smelling roots and water, early California sunlight filtering through the canes, I felt him there in a way that couldn't be explained but was real. And on that Friday afternoon, the 15th of March, the garden was gone. I want to say more about Harold, not to make this story more sorrowful than it needs to be, but because without understanding Harold, you can't understand why the garden was worth standing in front of a court to recover. Harold was a carpenter because he loved wood, not because he had no other options. His grades in high school were good enough for the University of California, but he told his parents at 18, "I want to make something that outlasts me." Wood, when worked right, outlasts you. The craftsman house we lived in was built in 1927 from good materials and good technique. 97 years later, it still stood solidly, its oak floors still firm underfoot. Harold understood that and respected it, Harold's philosophy of craft. When you make something with your hands, you put part of yourself into it, not in a mystical way, in a practical way. Every decision you make about angle, about joinery, about the species of wood, it's all in that object. And if you do it right, that object tells your story long after you're no longer here. The cedar trellises in the rose garden. Harold built each one in the small workshop behind the house. He drew the design beforehand in pencil on graph paper, calculating angles and spacing so the roses could climb easily, calculating load capacity for when the plants matured and when rain pooled on the canes. He used cedar because cedar weathers without chemical treatment and has a mild scent that, as he put it, doesn't compete with the flowers. When the court ordered Brandon and Diana to restore the trellises, I gave the carpenter the original drawings Harold had made. In the carpenter, a man named Carlos from Alhambra, held the plans for a moment and said, "Whoever drew these knew what he was doing." "He was a carpenter for 34 years, I said. "I can see that in the drawings." Carlos nodded. "I'll follow them exactly." Brandon and Diana moved into my house in September of 2023, 18 months after the transfer. They said temporarily, because their Arcadia apartment lease had ended, and they needed a place while they looked for a new house. Temporarily lasted 6 months and showed no sign of ending. In the first week Brandon and Diana were there, I understood that temporarily did not mean what I thought it meant. Week 1, workers came to repaint the master bedroom, the pale blue that Harold and I had chosen in 1996, the shade we spent an entire afternoon at the paint store finding, was replaced with a cold white that Diana called modern and clean. Week 3, the Persian rug in the living room disappeared. I came home and found bare wood floors. When I asked, and Diana said they had given away the old rug because it didn't match the aesthetic. Harold and I had bought that rug at an antique fair in Old Town Pasadena in 2001. Not the right aesthetic, I understood. It only held 20 years of our family's memory. Week 5. The walnut dining table Harold had commissioned from a craftsman in Ojai was gone, replaced by a glass and steel set Diana had bought from a furniture store on Colorado Boulevard. The old table was too heavy. It made the dining room dark and closed in, Diana explained. Every time I objected, Brandon had a ready answer. "This is our house. We have the right to decorate it how we want. And Diana, my daughter, the woman I had taught violin from age 7, who I had stayed up nights nursing through illness, whose college tuition I had paid, and whose voice I had been in her hardest adult afternoons. Diana did not contradict her husband. I retreated gradually, not because I chose to, but because every time I didn't retreat, I had to hear, "This is our house," and I didn't have the energy to fight that sentence every day. I retreated to the small bedroom at the end of the hall, Diana's old room as a child, and to the kitchen corner. Those were my remaining spaces in a house I had lived in for 36 years. And I looked out the kitchen window at the rose garden. In November, Brandon started talking about a pool. The Prestige Pools and Spas catalog appeared on the kitchen counter. A rough sketch of where the pool would go, directly over the rose garden, was taped to the refrigerator as though it were a normal document. "No," I said when I saw that sketch. "We haven't made a final decision," Diana said. "No," I said again. "I planted that garden over 23 years. That garden is where your father did his last work before he died. Nobody cuts it down." Brandon looked at me with a look I would not forget. Not anger, not fear. The steady calm of someone who knows the power is on his side. And then March came. 6 months of Brandon and Diana in my house were 6 months of learning to be invisible, somewhere I had been for 36 years. Every weekend they hosted gatherings, not large ones, usually 4 to 8 people, their friends, couples 15 to 20 years younger than me. They used the new outdoor grill Brandon had bought to replace the old charcoal, one Harold and I had used since 2003. They used the new patio furniture Diana had ordered from West Elm. They played music from a Bluetooth speaker. Music I wasn't accustomed to, not because it was bad, just not mine. I was not invited, not prohibited, just not invited. I learned this from the first time. I had stepped to the kitchen door to ask whether they needed anything, and the way Brandon looked at me, not unkind, just the look of someone who sees something that shouldn't be there, said enough. I went back inside, sat at the small kitchen table, read or looked out the front window, the side away from where they were entertaining. The feeling of being invisible in your own home is a strange and quiet kind of pain, not acute, not a sharp jab, but the wearing away kind, day by day, the kind of thing that drains out of you slowly until you notice you're emptier than you were. I remember one Saturday night in November, their gathering stretching to 11 o'clock, laughter and music coming through the walls. I lay in the small bedroom at the end of the hall and stared at the ceiling, the same white ceiling Harold had painted in 1995, and asked myself, is this what I signed? Is this what Brandon meant when he said I would still live there exactly as before? No, this was not what I had signed. And what I had signed, its actual legal dimension, had not yet been violated, not until the excavator arrived. 36 years I lived in the house on Wisteria Lane. I arrived at 32 with Harold and a 5-year-old daughter and a rented moving truck. Now I was 68 and still here. Most things in this house had changed at least once in those 36 years. Walls repainted, floors replaced, the kitchen remodeled in 2007. But the rose garden hadn't changed in its essential nature. It had grown and deepened over the years, but the logic of it, the way Harold and I designed it so every part of the backyard would have color in a different season. That had not changed. When Brandon and Diana moved in and began replacing the house's contents week by week, what I understood gradually was they were substituting their things for ours, and that had a logic to it if the house were truly theirs. But it wasn't entirely theirs, not in every sense. They had the deed, but I had the right of use. They had the decisions, but I had the contract clause. And more than anything, I had 36 years in that house, 23 years of the rose garden, and 40 years with Harold. Things that don't transfer through any deed of gift. I'm not saying this to deny their legal rights in the house. I'm saying it to say, when people say, "This is mine," and you're just a guest here, they're speaking of something very flat and very narrow. Documents matter and law matters. My story is proof of that. But whose house it truly is turns out to be far more complicated than the name on a title. Harold had a saying he used in the workshop: wood remembers everything. He meant that wood retains the record of its process. The grain reflects the environment where the tree grew. The cut marks reflect the craftsman's hand. The color reflects time. No piece of wood is a blank page. I think about that when I look at the new rose garden growing in the soil of the old one. Soil remembers. The roots of 23 years of roses had decomposed and become part of that earth. All those years of composting, turning the soil, watering correctly. That soil is good soil, in the way that good timber is good timber, not by accident, but as the result of care over many years. The new roses are setting their roots into that soil. They are learning from what was there before them. I want to tell you more about the Graham Thomas Rose and the award, not to boast, but because it is part of what was lost and what had to be recovered. Graham Thomas is the name of a variety bred by David Austin Roses of England, named after Graham Stuart Thomas, the noted English horticulturalist who spent decades preserving old rose varieties from extinction in the 20th century. The Graham Thomas rose is a pure, warm butter yellow, not lemon, not amber-tinged, but the warm yellow of generous blooms 4 inches across that grow in clusters on vigorous climbing canes. I planted my first Graham Thomas in 2003 from a young plant purchased at Heirloom Roses in Oregon. It took 3 years to reach maturity, and the first year it climbed Harold's trellis. But when it was established and in full bloom, spring of 2008, it flowered in a way that made me stand and look and not say anything. In 2015, I brought cut stems of Graham Thomas to the Pasadena Rose Society's annual rose show. The 3 judges, 1 from the American Rose Society and 2 from local Rose Society chapters, evaluated the technical quality of cultivation, the quality of the blooms, and what they called horticultural merit. When they read the first place winner's name in the Climbing Roses category, I was standing at the back of the room with a cup of coffee. The woman beside me, someone from Pasadena I'd never met, heard my name called and turned to ask, "Is that you?" "Yes," I said. "You should go up and receive it." She smiled. "They're waiting for you." I walked up, took the blue ribbon and certificate. She shook the chief judge's hand, and they photographed me with the Graham Thomas stems. That photograph is now in the album in my small bedroom. I also submitted it as evidence in the court file to establish the garden's significance. The irony is that Brandon knew about this award. I had told the whole household when it happened. But when he ordered the excavator to flatten the garden, he either didn't remember or didn't care. I suppose in the end it didn't matter which. Telling this story honestly requires me to speak about my own mistakes, not only Brandon and Diana's. Mistake 1, I didn't hire an attorney early enough in the process. I did eventually hire Carolyn Marsh. That was right. But I let Brandon guide the entire conversation about why to transfer for several weeks before I was clear-headed enough to say, I need to find out for myself. If I had sought independent legal advice from the beginning, before hearing enough of Brandon's argument, I might have asked different questions and been more cautious about the whole decision. Mistake 2, I signed without reading the full contract carefully enough. I had read the summary carefully and looked through the full contract. But looking through is different from reading carefully. Reading carefully means reading every clause, understanding every sentence, asking about every term you don't immediately grasp. I didn't do that. I trusted that Carolyn Marsh had reviewed it thoroughly, and she had, but the final responsibility when signing a major legal document is mine. Mistake 3, I didn't make sure I fully understood what would happen if the terms were violated, or rather, I didn't confirm that I understood the consequences clause. I knew there was language about specific performance and termination, but I hadn't really visualized what those words meant in practical terms until I sat with Patricia Osei. What I could not have known, that temporarily in Brandon and Diana's mouths didn't mean what I understood by it. That we won't do anything with the house was a statement about that moment, not a commitment about the future. That once the deed was in their name, the balance of power in that house would shift in a way that no one would say out loud, but everyone would feel. I'm not saying this to be hard on myself beyond what's warranted, but to be honest that situations like this usually arise from a combination of things: one person's decisions, another's actions, and genuine misunderstandings about what the same words mean to different people. The question isn't who is more at fault, but what do I need to do now and what tools do I have? Saturday, March 16th. I was awake at 5 in the morning, not because sleep had abandoned me entirely. I'd slept about 3 hours. But when I woke at 5, I knew I wouldn't go back to sleep, and there was something I needed to do. I went into the small bedroom at the end of the hall, Diana's old room, now my sleeping space, and also where I kept my important documents in a small wooden cabinet Harold had built in 1995. I needed to find the deed transfer agreement. The full contract, not the 2-page summary Brandon had shown me in 2022, but the actual signed document. I started going through the cabinet at 5:15. Harold had labeled each of the 4 drawers: property, insurance, taxes, other. The organizing system of a careful craftsman who believed everything should have its place. And the property drawer had more than I remembered. The purchase papers from 1988, several mortgage refinancings, building permits, and at the bottom, a thick envelope in Harold's handwriting. Transfer 2022. Adele, keep this copy. I stopped. Harold died in 2016. He couldn't have written this. I looked more carefully. Not Harold's handwriting. Harold's leaned right, the penmanship of a right-handed man who had learned to write in an era when American men often wrote in upright block letters. The lettering on this envelope was vertical and smaller. Mine. I had written this label myself, put it in the drawer, and forgotten. I opened the envelope. Inside was the complete transfer agreement, not the summary, along with handwritten notes I had taken at the time of signing. Questions I'd asked and answers I recalled. Scrawled on a piece of lined paper, and clipped behind it all was a printed email from someone named Carolyn Marsh, a name I did not immediately place. I started reading the contract from the beginning. It was 5:30 in the morning, the small bedside lamp casting yellow light, Brandon and Diana still asleep at the other end of the hall. It wasn't until page 7 that I found what I was looking for, not because I knew what I was looking for, but because one clause stopped me, and I read it 3 times to make certain I understood it correctly. Section 7.3, Life Estate Holder Rights and Property Restrictions. The life estate holder, Margaret Adele Whitmore, retains the right of exclusive occupancy for the duration of her natural life. Furthermore, and the remaindermen, Diana Louise Whitmore Ashford and Brandon Thomas Ashford, are prohibited from making any structural alterations, demolition, or removal of existing landscape elements without the express written consent of the life estate holder. This prohibition specifically includes, but is not limited to, existing trees, gardens, trellises, hardscape features, and any established plantings predating the transfer date. I read it a 4th time. A 5th. No alterations to the existing landscape without the written consent of the life estate holder. I was the life estate holder. The rose garden, established plantings predating the transfer date, was a landscape feature established before the transfer date. Brandon had signed this contract. Diana had signed this contract. And then they had destroyed the rose garden without asking me a single word. I put the contract down and looked out the small bedroom window. Pasadena in March, still dark, just a thin pale line along the horizon. Did they actually think I was too far gone to read a contract I had signed? Carolyn Marsh's email. I picked up the printout and read it. Carolyn Marsh was the real estate attorney I had hired independently in August of 2022. Not Brandon's attorney, but my own. Someone I sought out after Brandon showed me the summary, and I felt I needed my own person at the table. I had forgotten this. In the 2 years since, with everything that came after Harold's death, and then Diana and Brandon moving in, I had forgotten that I had once been careful enough to hire my own attorney. Carolyn Marsh's email, sent August 22nd, 2022, 3 weeks before I signed the contract, contained this paragraph. Miss Whitmore, I have reviewed the full life estate agreement and added several protective clauses that I strongly recommend you insist upon before signing. Most importantly, Section 7.3 prohibits the remainder men from altering, removing, or demolishing any existing landscape features without your written consent. I added this clause specifically because you mentioned your rose garden and wanted it protected. Please ensure this section remains in the final signed agreement. If they attempt to remove it, do not sign. I read that email, and the whole conversation with Carolyn Marsh came back to me. I remembered her voice, calm, professional, clear. I remembered her talking about the rose garden and the protective clause. And I remembered that when I signed, I had verified that Section 7.3 was still in the document. I had signed a contract that protected the garden. Brandon and Diana had signed a contract that protected the garden, and then they had destroyed it. I sat in that small bedroom with the contract in my lap until the sky had fully lightened. No crying, no explosive anger, just the cold, clear feeling of someone who now understood exactly what situation they were in. Monday, March 18th at 9 in the morning, I called Patricia Osei. I found Patricia Osei the simplest way. I tried Carolyn Marsh first, but her number was no longer in service. A search told me she had retired and moved to Florida in 2023. Her outgoing voicemail suggested several colleagues, among them Patricia Osei, at an office on Lake Avenue in Pasadena. Patricia Osei, a Ghanaian-American real estate attorney, 44 years old, answered after 2 rings. I explained the situation in 10 minutes. The life estate contract, Section 7.3, the garden's destruction, Brandon's words that I had no say. Patricia listened without interrupting. When I finished, she asked, "Do you have the original contract?" "Yes." "Do you have photographs or video of the garden before it was destroyed?" I thought for a moment. "Yes. I have photos from last year's Rose Society show and photos from a Pasadena Star News article in 2017, and personal photos on my phone from February of this year." "Good. Do you have any witness who knew the garden existed and who knows you never gave permission to remove it?" "My neighbor, Ruth Nakamura, at number 1849. We've known each other for 15 years. She was there Friday afternoon while the excavator was working. She came out and asked me what was happening." "Can you come to see me this afternoon?" "I can come right now if needed." Patricia's office was tidy and practical. No luxury decor, just full bookshelves, a clean desk, and natural light from a window overlooking Lake Avenue. She read the contract for 20 minutes without speaking, occasionally making pencil notes in the margins. "Section 7.3 is clear," she said when she finished. "This is a direct breach of contract. There is no ambiguity in the language. Established plantings includes your rose garden. Express written consent means a written document from you, and they don't have one." "What do you want?" Patricia asked. "I want them to replant the garden," I said. "Not financial compensation. I want the rose garden back." That's specific performance. Asking the court to enforce the actual contract term rather than awarding monetary damages, Patricia said. California courts generally grant this in real property cases because land is considered unique. Nothing else can truly substitute. And in your contract, Section 7.3 has a passage I want you to look at. She pointed to a sentence at the end of the clause I had read, but not paused it long enough. "In the event of material breach of this section, the life estate holder shall have the right to petition the court for specific performance, including mandatory restoration, and in cases of willful or repeated violation, termination of the life estate arrangement, which shall result in the remainder men forfeiting their right of occupancy pending resolution." Termination of the life estate arrangement. I read slowly. What does that mean in practice? It means that if the violation was willful or repeated, the court can require them to leave the property while the case is resolved. I sat with that for a moment. Carolyn Marsh wrote this clause for me, I said quietly. She wrote it very well, Patricia confirmed. Patricia Osei had studied at UCLA Law School and come to Pasadena to open her practice in 2011 because, as she told me over lunch the following month, I wanted to work in a community I understood, not in a glass tower in downtown Los Angeles. She specialized in real estate and estate law, not by accident. She told me that her father, a Ghanaian immigrant, had lost his home in Compton in 1995 because he didn't understand a clause in a mortgage contract. That's why I do this work, she said. Not everyone has someone who explains clearly what they're signing. What Patricia said to me after the hearing, the thing I'll carry. Miss Whitmore, many people are in your situation. They've transferred the house to their children without adequate legal protection and then find themselves treated like a guest in their own home. And the difference in your case is that you had the right clause in your contract and you went looking for it. Many people have good contracts but don't go looking because they don't think they can win. She added that clause, I said, thinking of Carolyn Marsh. Carolyn Marsh added that clause, Patricia agreed. But you were careful enough to hire her, and you were the one who kept the contract, and you were the one who found it when you needed it. Patricia looked at me. You didn't win just because the law was on your side. You won because you acted. Wednesday, March 20th, Patricia sent the official legal warning letter to Brandon and Diana Ashford. The letter went by email and by certified mail, addressed by full legal name, not the Ashford family or the parties, but each person's complete name. The letter specified violation of Section 7.3 of the Life Estate Agreement. Demand to immediately cease all construction activity on the former garden land. Demand for a written response within 5 business days, indicating whether they were willing to negotiate restoration. And notice that if no response or an unsatisfactory response was received, my representative would file in California Superior Court, seeking specific performance and injunctive relief. Brandon received the email at 10:30 in the morning. I knew because I saw him check his phone at the kitchen table and his face change. He said nothing to me Wednesday, nothing Thursday. Friday, March 22nd at 7 in the evening after dinner, Brandon came to the kitchen corner where I was sitting and reading. You filed against us? Not a question. A confirmation. My attorney sent a notice of breach, I said without looking up. That's not a lawsuit. That's a notification of contract violation and an opportunity to resolve before a lawsuit becomes necessary. Do you understand that you're fracturing this family? His voice had shifted. No longer the level calm, but something underneath it, the thing people call controlled anger that isn't quite controlled. I'm not fracturing anything. I set the book down and looked directly at him for the first time that evening. You violated a contract you signed. That's what fractured things. You don't have the right. You said that last Friday. I stood up. Not from anger, but because I wanted to speak with him standing, not looking up from a seat. And it's wrong? Section 7.3 of the contract you signed gives me the right to approve any landscape change. You didn't ask me. You destroyed my garden. That is a breach of contract under California law, not my personal opinion, not a matter of family feelings, a fact. Brandon looked at me for a moment. Then he said what I'll remember for the rest of my life. You're old. You need to learn how to let go. I am 68 years old, I said. I have lived long enough to know which things are worth holding and which are worth releasing. And this garden and my legal rights in this house belong in the first category. Brandon left the kitchen. Diana had been standing in the doorway through the entire exchange and said not a word, not in support of me, not in support of her husband. She just stood there and watched with the look of someone who knows she can't stand on both sides, but isn't ready to choose. Monday, March 25th, 9 a.m. Los Angeles Superior Court at the Pasadena Courthouse on Garfield Avenue. Patricia had filed for an emergency determination. Under California law, when there is a clear real property contract breach, and the breaching party is continuing to cause harm, the court can hear the matter on an expedited basis. Our case qualified. The contract language was clear. The breach had already occurred, and harm continued if pool construction resumed. Brandon and Diana arrived with their attorney, a man about 10 years younger than Patricia, in a gray suit, carrying a thick file. They sat on one side of the table. Patricia and I sat on the other. And the judge was named Harrington, a woman of about 55 with horn-rimmed glasses, and the expression of someone who has sat on the bench long enough to be impressed by no one. She read the file in silence for 15 minutes before allowing the parties to present. Brandon's attorney argued that Section 7.3 contained ambiguous language and that established plantings did not necessarily include roses because roses were short-lived plants, requiring periodic replacement. He also argued that demolishing the garden was a lawful improvement to real property, and that the pool would increase the property's value, which actually benefited me, since I still held a life estate. Patricia presented more briefly and with no ambiguity at any point. Section 7.3 specifically listed existing trees, gardens, trellises, hardscape features, or on any established plantings. No language excluded roses. The garden had existed for 23 years and was documented in public records. My consent had never been given in writing, and the damage was irreversible if construction continued. Judge Harrington looked at the file once more. Then she looked up toward Brandon and Diana and made 4 statements I would not forget. Section 7.3 is not ambiguous. Garden means garden, including a rose garden. Express written consent means clear written consent, not implied agreement. There is no evidence that such consent was ever given. There was a moment in that courtroom I want to describe because it doesn't appear in the official transcript. When Brandon's attorney presented his argument that established plantings didn't include roses because roses are short-lived plants, requiring periodic replacement, Judge Harrington looked at him over her glasses and asked, "Counsel, how long do roses live when properly maintained?" Brandon's attorney answered with uncertainty, "Perhaps a few years." "Some heritage rose varieties live more than 100 years, Judge Harrington said. Her tone wasn't judgmental, just factual. The garden that was destroyed had been established for 23 years and contained several mature specimens. I don't see the basis for classifying it as short-lived." Brandon's attorney looked down at his file. Patricia said quietly to me afterward, "Judge Harrington is a gardener." "She is?" "She has a rose garden at her home in San Marino. I know this from a small interview piece in the Los Angeles Bar Association newsletter last year. Patricia's voice had something slightly lighter in it. That doesn't affect her objectivity, but it means she understands what's being discussed. I didn't know this before the hearing and had no reason to think it influenced the outcome in any improper way. Section 7.3 was clear and needed no Rose enthusiast to interpret it. But there was something in that moment, in Judge Harrington's question about how long roses live, that made me think of Harold. He had built the trellises to bear the weight of mature rose plants, had calculated carefully because he believed the garden would outlast him. And he was right about that. The garden had stood for 23 years. Only human hands had ended it. Wednesday, March 27th, the formal judgment was issued. Judge Harrington ruled as follows. Brandon and Diana Ashford had violated Section 7.3 of the Life Estate Agreement dated September 21st, 2022. The violation was willful. The breaching parties had been put on notice of this clause through their signatures on the contract and had caused partly irreversible harm. Specific performance ordered. Brandon and Diana Ashford must restore the rose garden to a condition equivalent to its state before destruction within 60 days. Equivalent was defined as planting no fewer than 27 rose plants of varieties comparable to those that had been destroyed, restoring or replacing all trellises, and ensuring the garden structure was in suitable condition for healthy plant establishment. Compliance would be assessed by an independent horticulturalist appointed by the court. All restoration costs to be borne by Brandon and Diana Ashford. The pool project was permanently enjoined at its current location, the backyard site of the former rose garden, until Section 7.3 was satisfied, or a new written agreement was executed between the parties. And on legal costs, Brandon and Diana Ashford were required to pay all of the plaintiff's legal fees, the court having determined the violation was willful. When the clerk finished reading the ruling, the courtroom was quiet for a few seconds. Then Patricia quietly placed her hand over mine. Brandon looked straight ahead. Diana looked down at her hands. I didn't feel victory in the sense of elation. I felt something different, something tired and painful, but also solid and true. In the weeks after the ruling, the house on Wisteria Lane changed the way air changes before rain. Not peaceful, not easy, but at least honest. Brandon and Diana didn't leave right away. The ruling didn't require them to. It required them to restore the garden. And they remained in the house, but everything was different. Brandon stopped saying, "This is our house," in the way he had used it to close down conversation. Not because his view had changed, but because the sentence had been answered by the court in a way he couldn't contradict. The house was still legally theirs, but my rights in it were real and enforced by law. Diana knocked on my bedroom door the Thursday evening after the ruling. I opened it, and we looked at each other for about 10 seconds without speaking. Then she said, "I'm sorry, Mom." I stood at the threshold and thought about that apology, not about whether to forgive. That question is more complicated and takes longer than one evening, but about what Diana was actually sorry for. The rose garden? For letting Brandon speak while she stayed silent, for allowing the house to become a battlefield, or for all of it. "I hear you," I said finally. Not "I accept" or "it's fine." Just "I hear you." because I did hear her, and sometimes that's enough to begin. I want to say more about the morning when Diana came outside with 2 cups of coffee, the morning in July that I closed the story with. What Diana didn't say that morning, didn't say in words, but I think I understood, was that she was trying, not apologizing again, not explaining, just sitting here in your garden with coffee and nothing else. That was how Diana learned to do things when she was small. Watch first, try one small step at a time, not ask many questions. At 8 years old, when she wanted to learn to make strawberry jam, she didn't ask me to teach her. She stood next to me in the kitchen every summer while I made jam and watched. Then one day she asked, "Mom, can I try?" That July morning, she didn't ask. She just brought out 2 cups and sat down. I don't know what that means for the future, about Brandon and Diana and this house. Those things are more complicated than one morning. But she came outside, and I nodded, and we sat together in the rose garden while it bloomed. In 36 years in this house, I had drunk my morning coffee alone for 16 of them after Harold died. Before that, I drank it with Harold. That July morning was the first time I shared it with someone else in a long time. The garden doesn't concern itself with the stories of the people who tend it. It just grows, pulling water up from its roots, opening petals in the morning and closing them in the evening. But the person sitting in the garden with coffee, watching the yellow roses in the early light, that person carries her whole story with her. And sometimes that story needs space to continue. The court appointed Thomas Yamaguchi, a rose specialist from Rose Hills Memorial Park in Whittier, to supervise the restoration. Mr. Yamaguchi came to the house on April 3rd to assess the situation. He looked at the leveled plot of dirt and then asked me very specific questions. Which rose varieties, what year each was planted, soil depth, irrigation system. "Do you have detailed photographs of the garden?" he asked. I took out my phone. I had hundreds of photographs, from shows, from morning sessions in the garden, from blooming seasons across the years. I also had the garden journal I had kept since 1991, recording the planting date of each plant, the variety, its source, care notes. Mr. Yamaguchi looked at the journal with the expression of someone who has encountered something unexpected. "You've kept records like this for 30 years?" "That's how Harold taught me," I said. "He was a carpenter. He said if you don't keep records, you have nothing to learn from." With the journal and photographs, Mr. Yamaguchi was able to compile a nearly exact list of the varieties the garden had contained. Not all were immediately available. Some heritage varieties exist only at specialty nurseries. But he had a list and he knew how to find them. In mid-April, Brandon and Diana signed a contract with Heritage Rose Nursery in Claremont, a specialist in old garden roses that Mr. Yamaguchi recommended. 27 rose plants, including 3 Graham Thomas climbers sourced from a nursery in Oregon, 8 David Austin old garden varieties from my list, and the remaining varieties sourced from multiple suppliers. Total cost, $42,000, not including labor for planting and rebuilding the trellises, all paid by Brandon and Diana. On April 26th, exactly 60 days after the ruling, Heritage Rose nursery workers arrived with the plants. I stood at the kitchen door watching them unload the crates from the truck. Ruth Nakamura, my neighbor, stood at the fence watching. "Adele," she called, They're replanting? Replanting, I said. I've never seen this in 20 years of living here, she said. Never seen anyone ordered to replant someone else's garden. They signed a contract, I said, and the contract held. The interesting thing about planting roses is that they don't behave like other plants when they're getting established in new ground. When you plant a rose, especially a heritage variety, it doesn't spring to life immediately the way fast-growing annuals do. It goes quiet first. There might be 2 or 3 weeks where you see nothing changing above the soil surface. No new leaves, no new buds. People who are new to rose growing come to me worried and ask, "Did it die?" No. The plant is underground, putting down roots before it puts out leaves. Roses prioritize roots over leaves. They need to know they're standing firm before they grow upward. And when the roots are deep enough and wide enough, the plant breaks out. New leaves, new buds, and if the conditions are right, blooms within 6 to 8 weeks. And there's something in how a rose establishes itself that I find myself thinking about not only as a gardening fact. Important things often do this. Go quiet first, do the work below the surface first, and only grow upward when the foundation is solid enough. In May, when I saw the first Graham Thomas put out new leaves, the characteristic copper red that David Austin roses show before they go green, I crouched beside it and looked at it for a while. 23 years ago, the first Graham Thomas I ever planted also went quiet for 3 weeks. Harold stood next to me and asked, "Will it live, Adele?" And I said, "It's underground, Harold. Give it time." And then the new leaves appeared. I thought of that when I looked at the new Graham Thomas. Then I stood up, got the watering can, and continued my morning's work. After the ruling, when the story spread through the Rose Society of Pasadena, I received something I hadn't fully anticipated: support. Not everyone in the club knew the details of my situation. I hadn't told it widely. But the chapter president, Helen Fujimoto, knew because I had asked her about Heritage Rose Nursery when I needed advice on finding the lost varieties back. She asked why I needed to find them, and I told her. The following week, Helen called and said, "Adele, I spoke with some of the members. We have cuttings of several varieties you lost, especially the Munstead wood, and several heritage varieties on your list. If you'd like, we'd like to contribute some plants to the new garden." I sat with the phone and couldn't speak for about 10 seconds. "Helen," I finally said, I don't know what to say." "You don't need to say anything," she said. "You've been a member of this group for 20 years. You've helped many people learn about roses. This is just what people in a community do when a member needs something." 12 plants came from Rose Society members, some from their own gardens, some they had specially ordered when they heard what I needed. Those 12 are among the 27 plants now growing in the restored garden. When I think about this story and about Brandon and Diana and the contract and the court, I often find myself thinking about the larger picture, not just the betrayal and the legal victory, but the wider web. Ruth Nakamura at the fence, a witness. Helen Fujimoto and the Rose Society members giving plants. Carlos the carpenter reading Harold's drawings and nodding. Patricia Osei, a daughter of an immigrant who lost a house, working to make sure I didn't lose a garden. Those people are as much a part of this story as Brandon and Diana. Roses don't bloom the day you plant them. This is something people who don't garden don't fully understand. that a newly planted rose needs time to establish its roots before it flowers. Usually 1 to 2 months for mature plants, longer for younger ones. During that time, you water, you're patient, and you trust the process. I started tending the new garden from the first day the plants went in. Not because the court required me to. The court only required Brandon and Diana to plant them. It didn't require me to care for them. But this was my rose garden, and I tended my rose garden. The first Saturday morning after the planting, I was up at 6 in my garden clothes, in the backyard with a watering can and my leather gloves. This was what I had done for 23 years and had never tired of. Brandon stood at the back door and looked out while I was watering. I knew he was standing there but didn't turn. After a while, I heard the door close. By mid-May, the first Graham Thomas had begun to bud. The Graham Thomas climbing rose. David Austin's warm yellow variety, the one the 2015 show judges had called exceptional, was budding on the new trellis that Carlos had built from Harold's original drawings. I stood next to the plant and looked at the small, pale green bud. "Harold," I said quietly, "it's budding." In early June, the first roses bloomed. Not the Graham Thomas, that one was a little slower, but the Munstead Wood, deep cherry red, one of the varieties I had planted in 2007 and loved for its fragrance, in the way that's rare in modern roses, opened its first blooms. I cut one of those first blooms and put it in a small glass vase on the kitchen windowsill. The windowsill I had looked out from every morning for 36 years. I'm writing these words on a morning in July, sitting at the kitchen table with a cup of coffee, the window open and a California summer breeze coming through. From the window, I can see the backyard. The rose garden is in its second flush of bloom. Not the same garden as last year, it can't be. New plants are not old plants, and a 23-year garden cannot be perfectly replaced in a few months. But it is coming back. The Graham Thomas opened its first blooms last week, that warm butter yellow, exactly as I remembered. Brandon and Diana are still living in this house. Nothing is fully resolved between us. Things like this don't resolve in a few months. But Brandon has stopped saying this is our house in the way he used it to shut me down. And Diana has begun to sit with me at the kitchen table sometimes in the morning, not saying much, just drinking coffee together in the simplest way. I want to say more about Diana because the story isn't fair if I only see her as part of the problem rather than as my daughter. Diana Louise Whitmore grew up in this house. She studied violin from age 7. I taught her early mornings before school, and quit at 14 because sports mattered more in a teenager's world. She studied dentistry at UCLA, graduated in 2007, opened her own practice in 2013. Diana was intelligent, patient with patients, and by all accounts in her professional life, deeply committed. I had seen those qualities since she was small, and I was proud of them. What I didn't understand enough was that Brandon had influence over her in a way I didn't see until too late. Not violence or obvious control, something subtler. Brandon held clear, assertive views about every decision, and in Diana, over the years of their marriage, had gradually let him define good and right, rather than defining those things herself. I had seen signs of this without naming it correctly. She often glanced at Brandon before answering questions I'd asked at dinner. She often began sentences with "Brandon thinks" rather than "I think." She agreed to things in the house, the dining table, the carpet, the paint, that I didn't believe she actually wanted. When Diana knocked on my door after the ruling and said, "I'm sorry, Mom," I think she was apologizing for many things at once, not only the rose garden, perhaps for the years of not speaking up when she should have, perhaps for the distance between who she was and who she had allowed herself to become inside this house. I don't know which direction that will go in the years ahead. I only know that she knocked and said she was sorry, not because she lost a legal case, but because she felt it. And that's where things can begin. In the 2 weeks between the garden's destruction and the court ruling, 2 short weeks that felt like months, I woke every morning and stood at the kitchen window and looked at the empty ground. No color, no morning scent, that gentle fragrance of roses in the dew that I had woken to every day for years. Only flat brown dirt and the pool marking stakes and the smell of new concrete from the foundation that had been poured before construction was halted by the court. Some of those mornings I sat at the kitchen table for a full hour without touching my coffee, just sitting, looking, not from despair, but because I needed to feel the full weight of the loss before I could do what came next. And people often want to skip this step, the part where you sit with the loss and actually feel it, because it's uncomfortable and because the world keeps saying, "Move on and be strong." But I was 68 years old and had lived through enough to know that what you don't allow yourself to feel completely never really passes. After I had felt it completely, I stood up, washed my face, and called Patricia Osei. That was the right order of things. After my story became more widely known, through a small piece in the Rose Society newsletter and through conversations with friends, I was asked by several people, "I'm thinking of transferring my house to my children. What should I do?" I am not a legal expert, but I am someone who has been through this and learned something the hard way. So this is what I tell them. First and most important, hire your own attorney, not the attorney your child recommends, not a shared family attorney, your own attorney, someone whose legal obligation is to protect your interests, not the family's or the transactions. Carolyn Marsh added Section 7.3 to my contract because she was my attorney and she listened when I mentioned my rose garden and understood that I needed it protected in writing. Second, a life estate, the lifetime right of occupancy, is the most important clause in any home transfer when you intend to continue living there. But a life estate is only as strong as it is specific. The right to live here for life is not enough on its own. You need the right not to have the house's structure altered without your consent, the right not to have the landscape changed without your consent, the right to participate in decisions about maintenance, and a clause specifying the legal consequences if those conditions are violated. Third, keep records. Keep the original contract somewhere you can find it. Photograph your property regularly. Keep receipts, certificates, evidence of what you built and tended. Those things are proof of ownership in a deeper sense than any deed. And then fourth, don't sign anything simply because your son or daughter or son-in-law tells you it's good for you. That is not a sufficient reason. What's good for you is what you understand and agree to after receiving independent advice, not what someone else decides on your behalf. People often ask, not directly, but implicitly, through the way they hear this story, whether I have forgiven Diana and Brandon. I have thought about this question at length. Forgiveness is a word people use with several different meanings. Treat it as if it never happened, no longer angry, willing to continue the relationship, not seeking further punishment. These meanings aren't the same and don't necessarily arrive at the same time. I stopped being angry in the hot sense from the moment I stood in the courtroom and the ruling was read, not because I'm unusually noble, but because that energy had been directed somewhere useful and wasn't needed anymore once the work was done. I am willing to continue the relationship with Diana in the sense of not closing the door and of being willing to drink coffee together in the garden in the mornings. That is happening, one day at a time. With Brandon, it's different and will likely take longer, not because I'm holding on to anger deliberately, but because genuine trust requires time and demonstrated action, not only intention. Treat it as if it never happened. No, I don't do that. What happened, happened. The garden being destroyed was real. The months of living like a ghost in my own home were real. The words, "You have no say," that Brandon spoke were real, and I won't pretend they were unsaid. But I also don't want those things to be the only definition of the years I have left. I am 68. The garden is blooming. Pasadena mornings are still beautiful. And my garden journal still has many blank pages. I'll keep filling them. This morning I went out to the garden at 6:30. My old garden coat, my old sandals, the leather gloves Harold bought me from a shop on Mission Street in San Juan Capistrano 18 years ago, and they're still good because I've taken care of them. I stood in the middle of the garden in the early California morning light, that particular pale gold of Pasadena in July, before the sea breeze comes in from the coast. The Graham Thomas was climbing the new cedar trellis, its canes green and fresh with new buds forming. The Munstead wood had bloomed 7 times this week, its deep cherry red deep in the morning. I crouched to check the soil under a heritage rose planted last month. Moist at the right level, not too wet, not too dry. The roots were taking hold. The plant was alive. The thorn only hurts when you choose to step on it. Brandon and Diana chose to step on what was mine, not because they didn't know, but because they believed I would let them. They were wrong. I heard the back door open. I looked up. Diana was standing on the back step with 2 cups of coffee. She looked out at the garden and then at me. I nodded. She came out, set 1 cup on the step beside where I was crouching, then sat on that step with her own and looked at the blooming garden. We said nothing, just sat there in the early morning light with the sounds of birds and the smell of damp earth and the yellow of the Graham Thomas blooms that had opened yesterday. Sometimes that is how things begin to heal.